Hi, I'm Paul Skeith. I'm a business law partner at Richards Rodriguez Skeith. And on any given year, I'm probably working on 5 or 6 sales of a business. And when I do that, I notice there are a couple things that come up often that are problems and cause issues with the sale that really don't have to be if there was some planning ahead happening. The first thing, and this is sort of surprising to say, but just making sure that the legal documents actually say who owned the business and it's current. So sometimes clients over the years will have bought out partners or had new partners come in and their legal documents didn't keep up with it. So one thing that definitely will slow a transaction down and maybe even stop it is if the ownership documents don't say who actually owns it. That's something really to take care of before you start the sale process. The second thing that will really cause a problem in the sale of a business is if you've used independent contractors in the past to create key creative content. So, for example, maybe your logo or maybe your designs for the outside of your business, or if you're an intellectual property-based business, your key software or other material that's important for your customers and for the operation of your company. The issue is this. Independent contractors need to sign work-for-hire agreements and assignments to you as the owner. The problem is, if they don't, then they own the material that they created for you and you do not. When a buyer comes looking and wants to make sure that you own what you say you own, they'll say, wait a second, where are these documents? Trying to find those independent contractors 5 or 6 or 10 years later, though, can be really challenging. A third issue that often comes up has to do with your lease. Leases, whether it's for your office or for a factory or for your warehouse, often say that you can't assign the property to someone else. Sometimes people don't think, however, that that applies to a company buying your company, but it does. So taking a look at that lease early and seeing what the landlord has to agree to is very important. Ideally, a few years before it's time to sell your business, you'll want to negotiate with your landlord and put in the lease that it's not considered an assignment of the lease if the assignment goes with the sale of your business. A fourth issue, which can be a little bit touchy, is do your key employees have non-competes? And now you may say to me, Paul, we don't believe in non-competes. We want our employees to go anywhere that they want to, whenever they want to, and I totally understand that. The thing is, and the question that an owner has to ask himself or herself is, what will the new buyer want? If a new buyer comes in and says, you know, I have to have a non-compete with that key employee, and that key employee doesn't have one already, it can be a really difficult negotiation to get that key employee to sign a non-compete, especially when you're trying to keep quiet about the potential sale of the business. The last issue that I see all too often are when co-owners of a business aren't getting along and they don't agree on the sale. This can cause real problems, especially if one owner is tasked with getting the sale done, only at the very end of a long and expensive process, their partner says, you know, I don't think you did as good a job as I thought here. And then there's more lawyers, more accountants, and you're actually negotiating with your co-owners as well as the buyer. This is something that should be figured out ahead of time to make this process go smoothly. I think really the best thing to do is a few years out from when you're really serious about selling your business, you should start thinking about these topics. I'm also happy to have a conversation with business owners about these things so we can plan ahead and make the process smoother and increase the value of your business.